And thank you, and good evening. We have the jury has reached a verdict. We've been told that they had the verdict at 7:47 p.m. As previously noted, we're asking have the alternates who have been here for the process to come into court. We'll now bring the jury in. All right, thank you. Please be seated. We have the jury in the courtroom. I'll ask juror 4161 if you're the presiding juror.
Yes, sir.
Okay, and has the jury reached a verdict?
Yes, we have.
All right, thank you. Then I'd ask you to deliver the verdict to our bailiff. I have the verdict. It is with dissenting jurors. I'm going to provide the verdict to the clerk, ask her to make copies of the verdict and provide it to the attorneys. There's an issue on the verdicts that I want to discuss with the attorneys. So for that to be off the outside the presence of the jury, so I'm going to excuse the jurors.
All right.
The jurors are returned to their jury room, respective jury rooms. All right, thank you. Please be seated. Without at this point reading the verdict, I wanted to review with the attorneys the issues of the dissenting jurors. There's 2 dissenting jurors on each of the 2 questions, which leaves a verdict of 10 out of 12. The dissenting jurors, however, are different for each of the questions. One juror is the same dissenting juror on each question. Then there are 2 other dissenting jurors, one in each question. Now, that is a potential inconsistent verdict. However, my reading of the law indicates that although that's an inconsistency, that there are sufficient jurors with a consistent verdict to then have that be the verdict. I want the parties to be aware of that potential challenge. That's my reading of it. If you want to take a moment, this is all on a 5/6 verdict with 10 out of 12. There's potential for this to happen, and it's been a litigated issue. I copied one case, pertinent parts of the case, 163 Wisconsin 2nd, 439, Zentek, Z-I-N-T-E-K versus Perchik, P-E-R-C-H-I-K, with the pertinent discussion in it. If you wish to take a moment to read this, I'll provide it for you to read it before we go further, and we'll be in recess for a few moments.
Certainly, sir.
Right. I determined at times we'd have a sidebar conference, and we have a way to administer that, but I thought this is a better way to address the issues. That's why I asked the jury to be excluded at this point. So we'll be in recess for about 5 minutes. I'll give you an opportunity to read the case. Doing that, I am concerned that with the inconsistency. So I'll look for suggestions.
Judge, I'm very concerned as well. I don't believe, under the circumstances here, a juror can vote no for question 1 and yes for question 2. I don't believe that's jurors following the law under the circumstances. I don't believe this can be a valid verdict. The Zentek case doesn't, in my opinion, really touch on this issue, given the separate defendants in that case, and I think the issues are just very different. Again, I don't think, given the mandates of the law here, that if you answer question 1 yes, then you answer question 2. If you've answered question 1 no, I don't see under any circumstance how you can then answer question 2 yes. That's completely inconsistent, and I don't believe that juror's vote should be counted as a yes to question 2, and that does not leave 10 yes votes to question 2.
Attorney McMahon?
Your Honor, I think actually that Zintek would apply. And, Your Honor, the jury instruction does not state that the jury instruction gives instruction to the entire jury, not to individual jurors. And if 10 people have found that my client is mentally ill, then the question for the jury becomes, was she able to conform her conduct? Or was she able to recognize the wrongfulness? I believe that the analysis of Zintek that you need the requisite number of jurors for each question is appropriate here. Again, jury instructions are not specific to each juror. It is to the jury as a whole.
I read Zentek to state on the matter of inconsistencies in this type of verdict that it must be the same 10 jurors on each of the questions. And what I'm concerned about as I analyze the vote is that it's not the same 10. And that to me is the inconsistency in the verdict. Zentek addresses that issue. There's another case cited in that. I think it's Montgomery, Easy versus Montgomery Ward, that goes into more detail about that issue. So that would make it would bring about the inconsistent verdict issue. There is when I reviewed our jury instructions, the part of the jury instruction that discusses the 5/6 verdict does not include the language contained in instruction 180, which I'll send down. This may be a situation where the court would be in a position to give 180 and 520. 520 is the Allen instruction.
Well, and again, Judge, for the record, my concern is one juror dissenting on question 1, but answering yes to question 2, because it clearly states that if you've answered question 1 yes, then you answer the following question. So a no vote to question 1 does not allow that juror to give any other type of answer but a dissent to question 2.
Now, I believe that issue is addressed in, if not in Zantek, in the other case that I cited. That my view of the law is that if the same 10 within a package of questions, in Zentek case there was a civil liability case, 2 doctors, malpractice case. There was a dissenting juror in each, but different for each of the 2 doctors. There they found that wasn't an inconsistency because the same, for the liability questions for each defendant, there was the same dissenting juror. So I'm reading that analysis to mean that if there's the same 10 jurors on each question in a package, and I see this as a package, both questions 1 and 2 are necessary to decide the case, that that inconsistency can be overcome because it's the same 10, if it is the same 10. My concern is that in this case, it's not the same 10.
Well, and this is somewhat even different than Zintech because
Yes.
the questions here are such that you don't get to question 2. It's dependent upon your answer to question 1.
Correct. No, I understand that, and it's and you may be right. I haven't fully analyzed your argument, but I'm satisfied it's an inconsistent verdict. My suggestion to cure it is to give an opportunity for curing. Maybe it can't be cured. That's for the jury to decide. Is to provide them with the 180 instruction, which more clearly states the law on the 5-6 verdict, and to do a read the 520, which asks them to go back and continue to deliberate. So any comments on that solution?
I have no objection to that solution, Judge, at this point.
Your Honor, we're maintaining our position that the jury instruction on not guilty by reason of mental disease or defect does not specify that a juror who dissented on 1 cannot vote on 2. The jurors, clearly there are 10 jurors who felt that there was a mental disease or disorder. And the question then for the jury is, looking at that, do you find that the person can either not conform their conduct or lack substantial capacity to appreciate the wrongfulness? It's not directed to each juror. It is directed to the jury as a whole.
Well, again, although I appreciate the state's position, I'm reading the law to require the same 10 on each question. And this is not the same 10.
I understand that, Your Honor, but I don't believe that that is required because in mental disease or defect analysis in question 2, they don't require unanimity on what the jury finds there, just that it be found. You could have 5 that believe that the person couldn't conform their conduct, and 3 that believe they couldn't conform their conduct and they couldn't understand the wrongfulness, and a couple who just believe that they couldn't understand the wrongfulness. It doesn't require that.
I'm going to take a minute to review Zantac. Now, section 805.09 of the statute, sub 2, says a verdict agreed to by 5/6 of the jurors shall be the verdict of the jury. If more than one question must be answered to arrive at a verdict on the same claim, the same 5/6 of the jurors must agree on all questions. So the issue then, as presented by Attorney McMahon, is does question 1 and 2 constitute, as I called it, a package or a claim? I'm satisfied in reading the statute and looking at the nature of the questions in this case that you can't have a completed verdict unless a jury responds to both questions, questions 1 and 2, with the correct number. And we don't have that in this case. They have the opportunity to answer yes or no to both questions, and in order to have that yes or no be sustained, it has to be the same 10 on each question. So again, my proposal and my thought is that I will read 180 and instruct on 520, which is the Allen instruction, and they have the jury go back and continue based upon those additional items. So that'll be the order of the court, so ordered. With that being the case, we'll bring the jury in as well as the alternates so they hear the instruction.
All rise.
All jurors are back in the jury room, or back in the courtroom. You may be seated. The alternates are as well. The court reviewed the verdict. The verdict wasn't read in court. However, I did discuss the answers and the dissenting jurors with the attorneys and determined that I should re-instruct you on a portion of the verdict and have you go back and deliberate further based upon all of the instructions, including the new instructions that I'll give you at this time. So with that, then the alternate jurors are here so they can hear the instructions as well. And then we'll have copies for the 12 jurors who will be returned to the jury room. With that being said, I have the packet of instructions that you came in with along with the verdict form to be returned to you. Agreement by 10 or more jurors is sufficient to become your verdict. Jurors have a duty to consult with one another and to deliberate for the purpose of reaching agreement. If you can do so consistently with your duty as a juror, at least the same 10 jurors should agree on all the answers. I ask you to be unanimous if you can. At the bottom of the verdict, you'll find a place provided where dissenting jurors, if there be any, will sign their names, in this case use your juror numbers, and state the answer or answers of the verdict with which you do not agree. Either the blank lines or the space below them may be used for that purpose. You jurors are competent to decide the disputed issues of fact in this case. You jurors are as competent to decide the disputed issues of fact in this case as the next jury that may be called to determine such issues. You are not going to be made to agree, nor are you going to be kept out until you do agree. It is your duty to make an honest and sincere attempt to arrive at a verdict. Jurors should not be obstinate, they should be open-minded. They should listen to the arguments of others and talk matters over freely and fairly, and make an honest effort to come to a conclusion on all of the issues presented to them. You will please retire again to the jury room. With that, then, we'll give you these additional instructions, plus if you have before, return the jury to the jury room for further deliberations, consistent with the instructions I've read to you. So, jury's excused.
All rise.